You're watching The Legal Breakdown. Glenn, we are in the immediate aftermath of not only Jack Smith requesting a dismissal of Donald Trump's federal prosecutions, but now in D.C., Judge Chutkan actually accepting that request by Jack Smith. And so the cases against Trump in the federal court system are now gone. They're eliminated. My beef here is that Jack Smith deferred to the guidance at the Office of Legal Counsel that a sitting president can't be indicted. And so move forward under this notion that he had no choice but to dismiss the case. But what if he just didn't? I guess my question here is so what that that's what the OLC said, and that Democrats will bend over backwards, constantly making sure to follow the letter of the law to a T, even aspects of it that are not enforceable. The Office of Legal Counsel memo is not statute. It's just guidance for the DOJ. And yet we bend over backwards, making sure that we adhere to it, with every I dotted and every T crossed. And meanwhile, the opposite side is that Donald Trump is going to run roughshod over it as soon as it becomes politically inconvenient for him. So why did Democrats feel the need to just fall over themselves to defer completely, wholly, and totally to even unenforceable elements of the law? And yet we're doing this in the face of someone like Donald Trump, who will undermine that very system the moment he has the opportunity to do so.
Brian, that is exactly the right question, because why in the world did Jack Smith feel like he had to dismiss these cases against Donald Trump? And we've talked about that. We've talked about how he had a number of options. Sure, he could dismiss it without prejudice in hopes that maybe some future prosecutor would be able to re-indict it, rebring it, and finally prosecute Donald Trump for his crimes. Or he could have left it in existence. He could have left it up and running and let the Trump administration dismiss it, because that would feel like the product of corruption, right? A president of the United States ordering his DOJ officials to dismiss his own case, a case that was amply supported by the evidence that was developed against him. And I want to talk more about that evidence in a minute. Or he could have gone to Judge Chutkan and say, listen, I'm not asking you to dismiss it, but I'm asking you to just put a stay in place. Just pause it while Donald Trump is in office, such that we can pick up exactly where we left off when Donald Trump left office. Here is, after reading the 6-page motion filed by Jack Smith and Judge Chutkan's 2-page granting of that motion to dismiss, here is the argument that he made. And frankly, I think tactically, Brian, it was the only argument he was left with. He said, listen, the Department of Justice has a policy. They have interpreted the Constitution as somehow mandating that we can't prosecute a sitting criminal president. Now, I disagree with that interpretation, because there's nothing in the Constitution or, as you mentioned, in the law. There is no federal statute or in any appellate court precedent that says we can't prosecute a sitting criminal president. Indeed, I would think we'd want to, rather than giving a president carte blanche to commit all the crimes he wants against the American people with complete impunity and immunity above the law. That makes no sense. That, to me, Brian, is the stuff of banana republics. But that is the DOJ policy and interpretation of the Constitution. So Jack Smith said, listen, I may be special counsel, but I am still obligated to follow DOJ policy and the interpretation of the Constitution that the Office of Legal Counsel within the Department of Justice has announced. So I have nowhere to go. I cannot keep this case alive or up and running because I'm obliged to follow that policy. That's why he moved to dismiss it without prejudice. Now let's play this out. What if he didn't? What if he said, you know what? Kind of not unlike Glenn, I disagree with the policy, because the Constitution doesn't say that, even if the pinheads at the Office of Legal Counsel do. So I'm not going to move to dismiss it. I'm going to let Trump do it. You know what the Trump administration would have done, Brian? They would have come in with their new attorney general. Donald Trump would have said to the attorney general, well, don't y'all have a policy and a constitutional interpretation that says you can't prosecute a sitting president and you can't even have a criminal case up and running, even if it's on pause, on hold, during my presidency? And his attorney general would accurately say, yes, Mr. President, we do. And he could then say, well, shouldn't you be following that policy? And the incoming attorney general undoubtedly would have had his or her prosecutors move to dismiss the case. And then you know what they would have said? They would have said, you know what, Jack Smith illegally, in violation of the Constitution, refused to move to dismiss the case. It seems like he ought to be investigated and maybe even prosecuted, doesn't it? Donald Trump would say to the Attorney General.
Let me jump in here real quick and offer that, okay, Jack Smith didn't want to be the one to be accused of illegally subverting the Constitution, and so he had no choice but to dismiss. But in this case, either way, Trump gets the case dismissed. Either Jack Smith does it because he doesn't want to be viewed as being in violation of the Constitution, and he knows that the subsequent administration would say exactly that, or Trump's team dismisses it. But either way, it gets dismissed. So don't you want to at least have Jack Smith make an attempt at preserving this case for the future? Because in both instances, whether it's Jack Smith who does it or Trump's team who does it, either way, Trump gets away with it. So don't you want to at least have Jack Smith make an attempt to preserve this case in the future by virtue of not dismissing it?
Yeah, Brian, maybe you missed your calling as a lawyer. I think you've got your JD degree by now based on all of the discussions that we've had over the years. But yeah, it's a great point. But here is why what Jack Smith did actually preserved the opportunity to potentially jumpstart this case again when Donald Trump leaves office. If Donald Trump had his attorney general move to dismiss the case, saying, well, it's DOJ policy, right? Wink, wink. I am almost certain that the incoming attorney general would direct the prosecutors to file a motion to dismiss the case with prejudice. And those are two magic words. When you dismiss a case, when a judge grants a motion to dismiss a case, there is only one decision to make. Will the judge order it to be dismissed with prejudice or without prejudice? Without prejudice, which is what Jack Smith asked for and Judge Chutkan agreed to, means the case can potentially be rebrought, reindicted, and revived and prosecuted in the future. But if Donald Trump's, corrupt federal prosecutors came galloping in and said, no, Judge, we are moving to have it dismissed with prejudice. Now, there's no guarantee Judge Chutkan would have done it, but she might have if that is what the prosecution asked for. And of course, Donald Trump's defense attorneys would wholeheartedly agree it should be dismissed with prejudice. Then it is dead for all time. And so that is why if we look at just one sentence of Judge Chutkan's ruling in the case, she said, dismissal without prejudice, meaning it can be rebrought in the future, is consistent with the government's, meaning the prosecution's, understanding that the immunity afforded to a sitting president is temporary, expiring when they leave office. So that is what gives us a little bit of hope, a little glimmer of hope, however dim, that it can be rebrought in the future. That is what Jack Smith preserved by being the one who moved to dismiss it without prejudice.
So let's game this out for a second, and let's say that Trump is out of office in January of 2029, and what would have to happen then? Would another DOJ have to be installed? Would Jack Smith or another prosecutor who's seeking to pick up this case have to come into office? Would they go right back in front of Judge Chutkan and seek to resume this case? Can you walk us through a little bit of the mechanics of what we'd actually be looking at?
I can, and it would take another special prosecutor, or because Donald Trump would be out of office for all times. He couldn't, notwithstanding his, suggestion that maybe he'll be president for life and maybe he'll seek a third term, blah, blah, blah. I don't expect any of that will happen, but I didn't expect we'd be here either. So either there would be a new special counsel appointed, or there wouldn't necessarily even have to be, because Donald Trump would then not be president and not be a candidate. He would only be a former president.
So there would be no conflict of interest, and there would be no reason for an attorney general not to have to take the step of appointing a special prosecutor.
Exactly. Now, let me snuff out that dim light that I just talked about. Unfortunately, we got to call it the way we see it. Once Donald Trump gets back into office, there are at least three things he can do to make sure he's never prosecuted for his crimes. One, he could ask his prosecutors to go in and file what's called a motion for reconsideration with Judge Chutkan and say, we know you dismissed this case previously without prejudice. We want to file a brief and argue that it should now be dismissed with prejudice, and we're going to ask you to reconsider your earlier decision. I think that's an outlier because procedurally it might be barred, but I It wouldn't surprise me if Donald Trump had his federal prosecutors do that. That's one way to try to snuff it out permanently. The second way is a self-pardon. Donald Trump could come into office and say, now that I've got all the power, including the power of lawlessness bestowed upon me by the Supreme Court's presidential immunity ruling, they told me my pardon power is beyond review. I can sell pardons and there's nothing anybody can do about it. In that case, I'm giving myself a pardon for all crimes I committed the last go-round, either before, during, or after my first term in office. And the Supreme Court seems to have made itself a second-class branch of government and would probably ultimately rule self-pardons are just fine because it's plenary power and it's unreviewable. So that's the second way he could snuff it out. The third way is on his way out the door, whenever that might be. Maybe he resigns after 2 years and turns it over to Vice President J.D. Vance to be president, and he would negotiate with J.D. Vance a pardon. Little quid pro quo. I will resign. You can have the last 2 years of my presidency so I can go golf down at Mar-a-Lago with criminal immunity because you're going to give me a presidential blanket pardon. Those are three ways, Brian, I'm sorry to say, that Donald Trump can permanently snuff out what Jack Smith has just left open.
All right. Well, I wish we had a better note to end on, but again, to your exact point, I do think it's more important to call it as we see it here. And, some days we're going to have good news and some days we're going to have bad news. But one thing that we can guarantee is that we will be in this fight for the long haul, saying what we need to say and trying to bring accurate information to everybody who's watching. So with that said, if you want to follow along, please make sure to subscribe. The links to both of our channels are right here on this screen. It's also the best way to support our work. I'm Brian Tyler Cohen.
And I'm Glenn Kirshner.
You're watching The Legal Breakdown.